Danger, danger, Will Rogers. The anti-gunners have a new argument. I want to flag it and nip it in the bud. Let's talk about the in common use test and where it applies at the textual level or at the historical level. Stay tuned. Let's get geeky. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay, folks, California. In Duncan versus Bonta, California is trying to persuade Judge Benitez, and anti-gunners are doing this across the country, that the in common use test, which as you know is critically important for us to show that AR-15 bans, semi-automatic rifle bans, and magazine bans, including suppressor bans, are unconstitutional under the Second Amendment. The anti-gunners are arguing that in the two-step process, if you will, the plain text, as you know, of the Second Amendment has to be implicated, and then once implicated, the burden of proof shifts to the government to show that there are historical analog laws that were in effect at the time of the founding to justify the gun control law they're trying to justify in modern-day America. Now, the anti-gunners are trying to play a sleight of hand here, and I wanted to flag this to you because those of you out there litigating or looking to handle these cases, you need to understand this sleight of hand that the anti-gunners are trying to play. Specifically, they are trying to avoid desperately having the burden of proof shift to them to demonstrate that a modern-day gun control law is constitutional. Because as you know, in a criminal case, when I go into a criminal case, I am presumed innocent, and the government bears the burden to show beyond a reasonable doubt that I am guilty of a crime. In the context of the Second Amendment, once the plain text of the Second Amendment, as defined by the U.S. Supreme Court, applies to a modern-day gun control law, the burden shifts to the government to come forth to demonstrate that that gun control law is constitutional. In other words, the presumption is that that gun law is unconstitutional. When in doubt, throw it out. That is the burden the government must bear. And they don't want to bear the burden because it's very difficult for the government to win, and they know it. So what are they trying to do? Well, what they're trying to do is the government, such as California, is trying to elevate arguments that are really historical in nature and try to pretend those historical arguments are really textual arguments. They're conflating the plain text analysis of the Second Amendment as applied to the gun control law today with the historical analysis that the government bears the burden to come forth and prove. How do they do that? Let me give you an example by the state of California in Duncan versus Bonta, which is the case that deals with the the magazine ban. A magazine's over 10 rounds in the state of California. It's in front of Judge Benitez. This is the argument that California has raised, and you'll see my point, and then we're going to explain why it's clearly wrong. In footnote number 9 of the California supplemental brief, they write the following, quote, "The common use inquiry occurs at the textual stage, of the text and history standard. In Bruen, the court situated the common use inquiry in the textual stage of analysis rather than the historical stage at which the government bears the burden." No, wrong. Nope. California's wrong. Let's make it really simple. One of the key words, of course, in the Second Amendment that applies to whether or not magazines are protected is whether or not their arms are fall within the definition of arms. Well, we know in the words of the right of the people to keep and bear arms shall not be infringed. Well, here is what Nyserpa versus Bruen talked about arms. If obviously anything that can be used offensively or defensively is an arm, but so too is anything that helps. Here's the key word, folks, critical word I want you to take away from this video. Anything that helps facilitate the use of a weapon falls within the definition of arms. Don't trust me. I want you to read what the Supreme Court said. The Supreme Court said that the general definition of arms covers modern instruments that facilitate armed self-defense. Well, obviously magazines facilitate armed self-defense because they're needed to use semi-automatic rifles and allow them to be fired more than once without having to reload, which is really the definition of a modern firearm. Modern firearm, in my view, is really a semi-automatic pistol or a semi-automatic rifle. Those are what makes modern firearms. Modern firearms, and we know not only from Bruen and Heller, but also from Caetano in 2016, that modern firearms are indeed protected, and semi-automatic pistols and rifles are obviously modern firearms. Now, going back to whether or not the in common use test, remember that once the plain text of the Second Amendment is implicated, which means that an arm has been banned, if a magazine is an arm, which it clearly is because it helps facilitate self-defense, it helps facilitate the use of modern-day arms, thus it is an arm, among other reasons, and obviously, again, it's an essential component of a firearm because without a magazine, semi-automatic rifles and semi-automatic pistols don't work. So now that the plain text is implicated, we go to the historical, and this is critically important for our team, folks. Again, once the plain text is implicated when you're dealing with a gun ban or arms ban case, guess what happens? You apply the in common use test. You don't have to talk about historical analogs because the Supreme Court has already done the analysis of historical analogs in the Heller case. And when they looked at the historical analogs and the history, they concluded that weapons that were in common use by Americans for lawful purposes are protected arms under the Second Amendment. Let me read what the Heller case said about the types of arms that are protected. Again, don't trust Mark Smith. Look at the Heller case itself. This is what it wrote. This is Justice Scalia's opinion. Quote, "We may as well consider at this point what types of weapons Miller permits." The Supreme Court writes specifically, "Ordinarily, when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. The traditional militia was formed from a pool of men bringing arms in common use at the time for lawful purposes like, not only for, but like self-defense." The Supreme Court in Heller quotes a case called State versus Kessler out of Oregon that says, quote, "In the colonial and Revolutionary War era, small arms weapons used by militiamen and weapons used in defense of person and home were one and the same." Again, weapons that are in common use by Americans are protected arms at a minimum, not necessarily the only arms, but at a minimum they are certainly arms. They are if it's in common use, it is protected. But again, you see how in Heller they're talking about history here to come up with the in common use test. So you see what just happened there. The Heller decision comes up and discusses the in common use test in the context of the history of the United States, the history of the Second Amendment, the history of militias. This is important because don't let the anti-gunners try to say that the in common use test, which I've just demonstrated, comes from the history part of Heller, to somehow get elevated as part of the text. Because the reason why the anti-gunners want to talk about in common use at the textual level is because arguably the burden is on the plaintiffs who are pro 2A and not on the government. So it's, again, very simple. The text of the Second Amendment as interpreted by the Supreme Court, including when it comes to the context of arms, anything that helps facilitate arms is a protected arm. That's what Bruen says. Once that triggers, because magazines, for example, are arms because they help facilitate modern firearms, then you go to the historical component. But when you're dealing with an arms ban case, you're applying the in common use test by Americans for lawful purposes. In common use by Americans for lawful purposes. That is part of the historical component, which means that the government bears the burden to show that an AR-15 is not in common use. It bears the burden to show that a magazine is not in common use. It bears the burden to, for example, a suppressor, another thing that facilitates armed self-defense with modern-day firearms, that a suppressor is not in common use. The burden is on the government, and it's part of the historical part too, and not part of the textual. And don't let the anti-gunners get away with this, because we always want to shift the burden to the anti-gunners, to the state defendants. That is mission critical, because once it happens there, as a practical matter, they have it very difficult in terms of winning, because there are very few historical analog laws at the time of the founding they can draw from to justify their modern-day gun laws and their modern-day gun laws. And again, when it comes to the gun ban cases or the arms ban cases, you don't even have to get into the historical analog stuff. You simply ask, in modern-day America, is an AR-15 in common use? Undeniably yes. Are AK-47s that are semi-automatic in common use? Undeniably yes. Are magazines in common use in America? Undeniably yes. Are suppressors in common use in America? Undeniably yes. And therefore they should all be protected under the Second Amendment. But again, the burden to show they're not in common use lies with the government, because it's part of the historical component. That's where the in common use test came from in Heller. It was the historical discussion of Heller and not the textual analysis of the meaning of the Second Amendment at the textual level of the analysis. Okay, folks, hope you learned a little bit something here today. Don't let the anti-gunners get away with this. And again, if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.